Hello, everyone. I'm pleased to welcome you to today's webinar that celebrates the 50th anniversary of Downtown Legal Services, the Faculty of Law's community legal clinic and home to its public interest advocacy clinical legal education program. My name is Prasanna Balasundaram, and I'm the director of Downtown Legal Services. Before we begin, I wish to acknowledge the land on which the university operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit. Today, this meeting place is still home to many Indigenous people from across Turtle Island, and we're grateful to have the opportunity to work on this land. As a refugee and refugee lawyer, I also wish to acknowledge the impact of forced separation on Indigenous people from traditional lands, culture, language, and the right to self-determination. I recognize the sanctuary this land has afforded me is part of a wider set of colonial practices that displaced and dispossessed Indigenous peoples. I honor the Indigenous peoples that came before us and honor the excellence of the Indigenous community today. I will strive to be a good steward of this land and work to foster systems of love, justice, and equity. 50 years ago, a group of idealistic law students rose to the challenge of providing much needed legal services to low-income Torontonians. That original spirit of improving access to justice carries on with the students who step into the clinic today. Each year, approximately 150 students provide legal services to about 1,000 low-income City of Toronto residents. They work under the close supervision of the clinic's accomplished lawyers to provide services in the areas of housing, family, employment, criminal, refugee, and immigration law. They understand the law can have a uniquely devastating effect on low-income individuals and communities. Indeed, our clients are at the intersection of multiple and overlapping oppressions that are particularly vulnerable, I should say, due to the confluence of poverty, race, and disability. In response, students provide a broad array of legal services attempting to strike a difficult balance between serving individual needs and addressing underlying causes. They provide summary advice, negotiate settlements, and advocate vigorously at hearings and trials. Moreover, in recognition of various systemic factors that generate legal issues, they engage in public legal education, law reform, and systemic litigation. At DLS, U of T law students have a keen appreciation of the impact their work can have on people's lives. Our clinical legal education program focuses on critical, reflective practices. This approach seeks to transcend individual case analysis to examine, consider, and challenge underlying social, political, cultural, and economic patterns. The clinical experience allows students to consistently develop fresh insight into the social reality of law and legal institutions, and to explore ethical issues, and finally acquire crucial professional skills in service of increasing access to justice. Set against this background, I'm delighted to welcome Barbara Jackman, Dr. Barbara Landau, and the Honourable Justice Sheilah Martin for a special panel conversation to discuss the role of legal aid clinics in improving access to justice. Barbara Jackman earned her LLB from the University of Toronto Faculty of Law in 1976. She went on to practice, teach, and write on issues arising in citizenship, immigration, refugee, and national security law for over 30 years. Barbara was made a member of the Order of Canada in 2019, and I should say is a professional hero of mine. Dr. Barbara Landau is a psychologist, lawyer, and mediator, graduating with an LLB from the University of Toronto Faculty of Law in 1980 and an LLM from Osgoode. She's the president of Separation Pathways, a multidisciplinary, client-centered, affordable service for separating families. Dr. Landau was made a member of the Order of Canada earlier this year. And Justice Martin received a Master of Laws from the University of Alberta and a Doctorate of Juridical Science from the University of Toronto. Justice Martin was appointed to the Court of Queen's Bench for Alberta in 2005. In 2016, she was appointed to the Court of Appeals of Alberta, the Northwest Territories, and Nunavut. And in 2017, she was appointed to the Supreme Court of Canada. A warm and sincere welcome to our distinguished guests. Some quick housekeeping notes. If you have questions during the presentation, please use the question and answer function at the bottom of your screen. We ask that you do not record this session either through Zoom or any other personal recording device. Questions will be held until the presentation concludes. Thank you, everyone, and we look forward to the talk. So let's just jump right into it with an easy question, hoping to spark a little bit of discussion. What does access to justice mean to you? And maybe I'll start with Barbara Jackman, and then over to you, Dr. Landau, and then to you, Justice Martin.
Sorry, I always forget to turn my mute button back on. I think the short answer is that what you want for people is fair treatment in the determination of rights and obligations in a system that is inclusive and ensures impartial and independent decision-making on matters of significance to people. I think one of the aspects of access to justice is the right to legal counsel on significant matters. We don't have that anywhere in Canada, although they are aspiring to it in other countries like India. So I think that that's an important part of it, but it also goes further than that. It goes into how the system responds to difference. And I think Canada still has a long way to go in terms of educating or appointing people with diverse backgrounds and experiences that have some awareness and understanding that not everybody is the same.
Okay, are you wanting me to just start, Prasanna? Oh,
yes, please.
Oh,
yes,
okay.
please. Go
All
ahead.
right. So I know that we have limited time, and I want to applaud what Barbara said and just say I second it. I just want to say that as a U of T grad and someone who worked in the legal clinic before the beginning of time, I'm delighted to share the DLS 50th anniversary, and what an honor to be part of the panel. And I do want to invite Chief Justice Richard Wagner to our table. Today I read that he is enormously preoccupied by access to justice concerns, with about 30% of applications to the Supreme Court from unrepresented litigants. And we agree that this is a challenge. So for me, access to justice means that wherever possible, we make an effort to identify the barriers for clients from the client's perspective. And then we advocate for and attempt to remove those barriers. And I agree with whatever Barbara has already said. So I'm going to turn it to Justice Martin, to Sheilah.
Thank you. Of course, I endorse what was just said. I think when we look at access to justice, there's kind of two components. One is the access part, how you gain entry and the barriers that have long been studied, long been listed and recognized. But there's also the justice part. And my preoccupation is with the justice angle in the sense that we can have open armed access to a system, but if the fundamental rules of engagement are unfair, they will not lead to just results. So I like to look at justice in terms of a lens of a substantive equality, in terms of asking whether people's needs are being met, what is being delivered on the ground, does it follow a proper process, but does it, at the end of the day, do what it is that we're hoping can be done through law, limited narratives of law, limited potential perhaps in some ways, but my focus would be on, is this delivering to people the justice component of law?
If I could perhaps press you a little bit further, and I think Barb spoke a little bit about the specific sort of obstacles. Maybe I'll put it to the entire panel. What do you see as the biggest obstacles to access to justice in Canada? And I'm curious, given sort of the diversity of your career paths, can you describe how you encountered or recognized them?
I can start, right, given that I'm in private practice representing a diverse community. But I think one of the biggest problems is I mean, this might get people upset, but I represent people from varied backgrounds whose language is not English, whose first language is not English, who come from different cultures and often have very different norms and ways of communicating, and you know, everybody holds family important, but there's cultural differences in terms of, you know, who is family, even in some communities, which is not recognized in our law. But I think that the system that there is institutionalized racism, that the kinds of laws that have developed benefit certain classes of people and not other classes of people, even common law principles that have developed. And I think one of the key problems is that that's not being addressed. I mean, they may talk about it, but it's not being addressed. So for instance, if you look at the federal court, which I appear in front of, and I'm also in front of a lot of tribunals, why isn't the federal court split into two sections? One section that does people law and the other section that does tax and corporate law and mining law? Or it's out, we get judges who have no experience whatsoever in terms of handling refugee matters, who are really good judges, and but are experts in shipping law. And it's really inappropriate, I think, in a long-term sense, to have to maintain a myth that it's not that they're bad people, they're good people, they're good judges, but to maintain a myth that everybody is equal in terms of being a judge. They're not. They have different backgrounds, different strengths, different weaknesses. I guess I'm conscious of that as significant within the legal system because I do so much litigation for people. None of my clients are like Canadian-born Canadians. Mostly, they're all people who come from different places, and you can see over time the impact that has.
So I'm going to echo again what Barbara said, the idea of having the specialty. My first case in Superior Court was with a separating family that had every issue you could possibly think of, and it was a personal injury lawyer turned judge that week that was hearing the case, and it was not the best experience for the family. But I guess I want to talk from the family law perspective, because when you consider, and I appreciate the cultural differences are very important and faith-based differences, but when we look at both married and common law couples, we have almost every family that's touched by separation. And if we throw in the children and the extended family members, we can see that legal aid provides almost nothing for people that are appearing in court, and it provides less than nothing for people who are hoping to resolve their matters in a consensual fashion out of court. So that's something that is created. I know that Sheilah, you were going to talk about the law, but the access to justice part is where I'm probably more concerned. With COVID, people are told when they finally arrive at court to come back in 3 years because the courts are so overwhelmed, and the number of unrepresented people in family court between 60 and 80%. Thank goodness for the downtown legal services, because between 60 and 80% of litigants in family court are unrepresented. Maybe only 30% get to the Supreme Court, but imagine what it's like in the lower courts. And the other thing that I'm really concerned about is that even if legal aid did fund services out of court, the current system doesn't look at separating families from the client's perspective. It tends to look through the lens of family law statutes. But when people separate, there are all kinds of impacts that happen to them. And from the client's understanding, all of a sudden they're faced with they don't have affordable housing, and they've got immigration issues, and they've got mental health problems and addiction. They've got special needs children struggling with autism or whatever. And too often we in the legal profession look at it in terms of, what's their net family property, and questions that they're not ready to deal with. So I'm looking for a more holistic, multidisciplinary approach. And that's why I've created separation pathways in order to say to the client, what are your priority issues and how can we help you get to the end? And the end will include legal issues for sure, but sometimes people need to be helped with a number of other things so they feel secure enough to deal with, with their actual legal issues. The other thing I'm going to throw in is the concern around domestic violence. My concern is that we haven't required that lawyers and judges dealing with family matters are properly trained to understand the impact, the presence and the impact of domestic violence. And too often that results in situations of lack of safety, even women being killed. Somehow we seem to feel that if we walk out the door of the law school, we now know everything. We don't need to learn anything more, except perhaps some changes of the statute. But we don't look at it in terms of the clients that we're actually serving with those issues. So that's enough. I'll turn it over to Sheilah and then I'll come back with some more.
I just want to make sure that you don't think that my only preoccupation is the law. I was talking about the need for justice to be delivered at the end of the day.
Yes.
Of course, there's access issues, and many of them. My major exposure to them was either doing pro bono work on a constitutional side when I was a barrister, but most importantly, when I was a trial judge. When I was a trial judge for 12 and a half years, and sort of a third of our docket was family law, and almost all of that involved self-represented individuals. So when I look at that experience and seeing how the legal system responds to real people in crisis, I tend to agree that a multidisciplinary approach is very important. And if you look across the country, every court is trying to grapple with a systems-based approach to how do we best deal with people who have needs that might not be met by the adversarial system and might in fact be made a whole lot worse by the adversarial system. Because in a family law context, the minute you have competing and condemning affidavits, it's very difficult to try to get people back to a place of at least calm to be thinking about how to resolve issues and how to think about the best interests of children and the like. So if, from my perspective, I'd like to ask the question, if we were starting again now, knowing everything that we know about social context, about inequality, about unequal access, about costs and barriers and language, and in family law and in other areas of law, would we build the same system?
No.
Would we build a legal system?
No, we wouldn't.
Would we have a court-based notion of how people should be resolving problems? And it's kind of like we've renovated the house so many times, right? That you look at the house of justice or court systems and say, we probably wouldn't have built this from the beginning. So I think one of the barriers is that we are kind of lurch from one thing to another, rather than sometimes sitting down and saying, okay, is it time to redesign? Is it time to reorient? What other than a completely court-based process can work here, and probably in many, many instances work better? Not to necessarily institutionalize a court-like other process, but that I think is worth thinking about.
You know, I agree. Can I just add? But I think that there's an underlying issue there that needs to be addressed too, which is our approach and attitude towards people. Like it doesn't work if you are dismissive of people as people. Like if you don't, if someone's in pain, recognizing that pain, not trying to say it's not there or it doesn't count because you're not a citizen or something. Like, obviously I'm coming from my own experience as a lawyer, but there is that sense of not viewing people, not having, people don't, it's a denial of dignity. That's what it is. And I think that, and it's there with vulnerable people. And that includes Indigenous peoples and immigrants and people like that. And I know that on one level we're trying to deal with it, but it permeates the system of law, I think.
Yeah.
No. I mean, picking up on sort of the threads of your various comments, and perhaps taking Justice Martin's attempt at imagining a different system, let me ask you this. What is something that you see from your various vantage points that justice actors are getting right? And what is something that justice actors misunderstand or are getting wrong, and why? Maybe that could be sort of an entry point into that exercise of imagination.
Well, let me start on that. And I'll just go to what do I think certain people are getting right. I'm not as involved in the overall actors anymore, seeing that. But what I do see is an appreciation, Barbara, of what you were saying about understanding people and understanding that they have life experiences that may be different than the decision maker, and how seriously that's being taken in terms of judicial education around equality, around social context. And that to me is important because it's all about dignity and respect. Any process that we deliver that is trying to help people solve problems has to be part of a caring profession, which I believe the legal profession is, but it has to be, as you say, client focused, people focused, and understand what those needs are. So what do I see being done? I see judicial education programs that are serious, that are pedagogically very, very sound. I also see, though, a lot of advocacy, and the DLS is to be commended for this, in terms of making sure that the impact of laws on real people is before the court, and that is a part of the conversation that's critical to understanding what the appropriate or better legal rule is. And so I look to DLS and I see that they're before the Supreme Court on aberrates, that they were before standing committees on social policy and these kinds of things to ensure that there's advocacy grounded in the reality of people's lives, and that comes up and is part of, we can say, the record, but is part of what is relevant in terms of how we solve legal problems in a court-based system. And I think that's been improved. If we look over 50 years, we can see, there has been major strides made there. Of course, more to do. Of course, not a full answer, but that's what I see as one of the positives.
I'd love to add a little bit. I guess I totally agree with everything everybody has said. I think that when we look at family law in particular, I like to look at it, Barbara, not just from the range of diversity, which I do, but I like to put on the lens of the child. When we're talking about cases in which there is a need for an ongoing relationship, I think we need a very different kind of process than the current adversarial system that has people say terrible things about each other, line up all the witnesses, humiliate each other, and often ignore some of the needs that do need to be addressed, but are not part of the family law narrowly in the statute, and then think that they're going to be able to walk out of the courtroom and get along. Because from a child's perspective, in most cases, families are forever. And they need grandparents and extended family members and whatever. If I were redesigning the system, of course, we need to think about, cases where there's abuse and safety issues. But for those where there's going to be an ongoing relationship, I think we need a very different process. And I also would like to just quickly throw in, you mentioned what are some of the legal rules, some of the codes of conduct and stuff that we might need to change, particularly for family law. I think we have codes of conduct that apply to everything, and sometimes they're not as helpful in some areas of law as they are in others. So, for example, family lawyers are terribly reluctant to take partial retainers. If the clients can afford a little bit of legal help, but not the whole ball of whatever, lawyers are made to feel very insecure that, somehow they're going to be sued and their insurance won't cover them. So I'm just going to put on the table the issue of making lawyers feel okay about offering assistance that's better than not getting any assistance to help people with maybe perhaps a narrower range of problems that are important to them. I think the other thing is the decades-long struggle around paralegals. Of course, they need to be educated, but they're right now, and they need limits on their scope of practice. But yet again, in Ontario, the issue of paralegals has been shelved. And that's another way of providing some affordable assistance that's better than people just appearing in court without any assistance. And the final one I'm going to mention is the requirement to zealously advocate. So when you zealously advocate on every issue, you end up risking undermining the cooperation that's needed after court for people that need to get along. So again, I'm thinking about cases where there's an ongoing relationship and where we need some kind of understanding of the context of that type of legal dispute. That's all I'm going to throw in.
And the final word on this question to Barb, I know you had sort of pointed out legitimate areas where justice actors were getting things wrong. I'm curious, what do you see as an area where justice actors are getting something right? And what is it that we can learn from that if we were to, again, exercise our imaginations and rebuild?
I mean, I sound like I'm harping on diversity, but one of the things that really impressed me, I went to the bar, the call to the bar of one of my articling students, and the benchers that were announcing the students couldn't pronounce their names because they were from different cultures, different backgrounds. That is the most positive thing. We have a bar that is universal in terms of the people that belong to it. And over time, that will have, those people will populate the benches across the country as well, some of them, because people are aware that there's a need for that. There's a need for diversity, a need to recognize that we can't discriminate against people because of their last name or their color or whatever. So it's really, that's a positive development. And, I have an articling student usually, and it's just really positive to see the energy and the confidence that these young people have in their ability to shape the future. And, I wish them well. I think it's great.
Yeah, I mean, one of the things that I can observe just over my time here at DLS is the diversity of law students that we're starting to see at the University of Toronto Faculty of Law. And that's something that is very positive. It speaks exactly to what it is that you're speaking to, Barb.
I just have to throw in that in the 1960s, when I was going to apply to law school, the dean of one of the law schools, not U of T, said to me, why would they want to waste a position on a woman? You're just going to have babies and stay home. And besides that, nobody would hire you at the end. He said, except maybe to make coffee in the back room. I think we've moved a distance since then.
Definitely some much needed movement on that. I do want to focus a little bit on DLS. I mean, I'm curious, from your vantage points, how do you assess the impact of DLS or similarly situated institutions in improving access to justice? I mean, you spoke about this a little bit. In particular, what I want to kind of consider is whether institutions like DLS that were really created to respond to a gap on a temporary basis ultimately maintain inequities in access to justice.
Want me to go first again?
Sure, go right ahead. Jump
I don't
right
think that clinics maintain the problems with access to justice. Those problems are there. The clinics are serving a need. And I think, if they weren't there, there'd be less people served. So I think it's helpful that they're there. If you take, it's almost like a false dichotomy. You take away the clinic, there's not going to be something else in its place.
Right. I said, yeah.
Yeah.
I was thinking that if we ended the clinics, it would be like closing food banks before we had a guaranteed annual income or affordable housing. I think you do a wonderful job. And looking at the outline of the service and the experience, I've just had 2 law students working for me in the last semester, and they found it wonderful to see how law is applied and meet with real people and see the diversity of need. And they go back to their legal education really inspired with how they can make a difference. And also I noticed that you've got a multidisciplinary approach. You've got a social worker that's also dealing with the emotional fallout from some of these issues. So I'm seeing a real movement and an openness.
Can I just add too, Prasanna, that it shaped my career. My working in the clinics is why I ended up doing immigration law. It's not something I ever even thought of. It's just we were dealing with immigrants in the clinic. So it's not just that you're helping people, it's also shaping lawyers for the future.
And my experience, same clinic, a couple of years later, convinced me that I wanted to do family law, even though one of the law professors said, I'm sure, Barbara, scratch the surface and you'll find a corporate lawyer. But after my experience at working in the clinic, I definitely felt family law was where I was going. It's really interesting. Yeah.
Yeah, it does. It impacts.
And finally to you, Justice Martin.
Well, I guess I look at the question and I think ask the 1,000 people a year you help, whether or not you're doing a good job. I mean, it's just so obvious to me that people are being aided through what is probably the most difficult period of their lives with problems they can't solve themselves. So on that very human level, unless we can get rid of all the root causes, why would we be criticizing a service and saying that I don't understand that mentality? I think you do the structural things to make sure that you might not need the service, but it's going to be a long time in coming that people aren't going to need help through human problems. I think you're to be applauded and for the actual assistance. And as I was a prof as well and a dean, so we had clinical programs like this. I was very supportive of them. So supportive, we actually started to give credit for them. That I said, if you need to be valued. This is a valuable skill. So I think how clinics are sort of fit into and seen and appreciated in a law school is very important. But all I ever saw from that was growth. Exactly what education should provide is an experience that you didn't have before, that, we know the way law is taught, to actually have an opportunity to not read a case, but be part of a case and to see how it unfolds, to help structure it, but more importantly, to understand the dimensions of what brings an individual into the justice system and all of the problems that are behind sometimes that's that entree, and to understand what the role of law can be and what the role of a lawyer can be and how important it is. Not everything, but very important. And it absolutely shifted people's careers and their ideas. But most important to me, what it did was that it showed that the obligation to give back and the obligation to be in the community are proper parts of a professional's training, and they should be seen as a part of competence, not just something that maybe an individual might want to do.
Yeah.
I think we're coming to the close of sort of the discussion portion of the seminar today, but I do just want to tie this up and pick up on the comments that you've all said with respect to your either your time in a clinic or your time recognizing and appreciating the work of a clinic. What can a teaching clinic like DLS that's situated in a faculty of law do better to prepare law students to enter the profession with a sense of purpose and resolve to address some of these access to justice issues that we've talked about?
Okay.
Yeah, go ahead, Dr. Landau.
Okay, so I will put down as my comments, offer scholarships to good students from poor backgrounds, ensuring a range of cultural, color, and gender identity backgrounds, especially those whose families have experienced the type of issues that we hope to address: injustice, persecution, racism, having difficulty getting foreign credentials recognized, poverty issues. Also, engage students in advocacy and law reform and experiences that build a better shared society and that touch the students' hearts and minds. And then create competitions for ideas to better serve vulnerable populations. I bet Barbara Jackman is going to disagree with all of those ideas.
It's about time we maybe got some disagreement in here.
Oh, okay, yeah, right.
Over to
Sheilah
Barbara.
will just, yeah, no, yeah.
I agree with all of them. I think they're wonderful. I mean, I don't know what DLS is doing now, but I know that that through the cases that we took when we were in DLS was you learn from the cases, and that itself was the foundation for the future in terms of what you learn from that process. So I think hands-on work. I also think law reform is encouraging law reform. Like I remember we did a brief on the Immigration Act, and it was a great process. They were coming in with a new legislation. So by the time we were lawyers, we knew that legislation inside out, and we understood the problems with it because we'd done so much work in it, in that area, in terms of criticizing the proposed draft. So that kind of work that students can do. And I remember one of the government bureaucrats telling us that ours was the best brief, the U of T.
Oh,
yeah, no, it was good. And
yeah.
There was about 12 of us involved. Everybody did a different part of it. But that kind of experience is really helpful, I think, in terms of understanding law and how it impacts on people.
And finally to you, Justice Martin.
Well, I think most has been said, but if I could just add that I think that it's really important that the importance of clinics be recognized in law schools. And I'm not saying anything that it's not, but sometimes there's the feeling that there's the substantive law, that there's the real study of law, and that this is just somehow a skill or a personal preference that somebody wants to learn or to help or whatever. And if I could do anything, I would break down that notion of the difference between theory and practice, and the idea of what we have law for being removed from who it is we serve.
yes.
Certainly, and I think we are starting to see that kind of development permeate within the legal academy, where there are professors who teach Black letter law who are looking to incorporate experiential learning and looking to the legal clinics to see how the pedagogy that we've been implementing here for decades can be incorporated into sort of the core, if you will, law school curriculum. So it is.
If you end up, I brought an example of the case that really made such an impact on me, and I'm remembering it 50 years later. So that's, if you had an extra minute, but if you have questions, let's go to the questions. I just brought an example of my experience when I was.
No, Dr. Landau, we definitely have a minute to hear your experience.
Oh, okay, I'm going to
go ahead,
okay,
please.
This one, you're going to enjoy this, because remember, this is not today. Okay, so I volunteered at 311 Jarvis, a familiar haunt, as I had been the chief psychologist at the family court clinic, which that's what we need. We need the family court clinic again. the funding was cut, but we need that back. Okay, anyway, a client approached me with allegations of domestic violence. She'd been told by a court staff that domestic violence is not an issue for family court. It's an issue for criminal court. So they put her in a cab and sent her to City Hall in those days. That was the criminal court. When she arrived, the duty counsel in the City Hall court said, your case is not appropriate because we only hear assault bodily harm cases. Yours is a domestic. So they put her in a cab and they sent her back to 311 Jarvis. When she returned, I asked if she'd spoken to a lawyer and she said no, because she didn't have any money. So I offered to accompany her into the legal aid office. I sat quietly as a support person and a learning experience for me. The legal aid staff took down basic information and then leaned forward and said, you're a nice lady. You don't really want to pursue this case. You'll just return home. Most women do, and it'll make matters worse. The woman looked defeated and confused. So after the meeting, I asked if the woman would like my help. She was clearly afraid to return home and wanted to separate. I asked if we could talk to the Crown that would prosecute her case. At that time, there were no crowns in 311 doing domestic assaults, but there were crowns for juvenile delinquents. So I arranged to meet with two of them. One of them at least became a judge afterwards. But anyway, the outcome was that the system changed so that the crowns were assigned to domestics at twice a week. There was more that we could do, I thought. So she still did not have counsel and she didn't understand how to present her story. What was hearsay, what was evidence? So with the help of the two crowns, we designed a form that led the litigants through how to prepare her testimony. And it raised her competence and her confidence as a litigant. The experience was pivotal for me as a law student because I learned to listen to a vulnerable person and advocate, not accept a system where the policies had failed to meet the client's needs. I just wanted to give that example because it has stayed with me. You can make a difference, even as a totally inept law student.
No, thank you. Thank you for sharing that, Dr. Landau. I mean, you speak of a case that you encountered when you were in law school, and I want to now move to the question and answer part of the seminar. And I actually have a question that brings the issues that you were engaging with to present time. And I'm going to ask all of you a question that's been posed by one of the audience members. Do you think that there is less access to justice for women and or certain types of legal issues, example, sexual assault and domestic violence? Go ahead, Dr. Landau. I mean, you were already speaking on this topic.
I'm going to say absolutely. I want to be sure that I hear the others' perspective. But the thing that is so frustrating, I'm running this new innovative program, Separation Pathways, and so far, all of our referrals have been from a legal clinic, and almost nobody has the ability to pay even a small amount. And there is no legal aid funding for the law clinics to deal with family matters, particularly not matters that are out of court. So, and I'm finding that, of course, the majority of people that are coming forward are women, not all women, not all just women. And we have people with all kinds of family law, but other issues, somebody who's blind, somebody who's dyslexic and can't read court forms, someone with an addicted child who's worried that they're going to die from fentanyl, whatever. But yes, there is definitely a disadvantage for that population. And domestic violence, by the way, from the legal clinic, we do a screening for domestic violence immediately, and we found about 50% of the cases have concerns about domestic violence, and we immediately refer those cases to our partners, the Barbara Schleifer Clinic or Luke's Place. And I have to say that my heroes are Deepa Mattu, who's just getting the Law Society Medal, and Julie McFarland representing the unrepresented, and Chris Bentley, who's done a lot to improve access, but not so much yet for out of court.
So I'll give you an entirely different example, but there's this, the Immigration Appeal Board has a humanitarian and compassionate jurisdiction to let people overcome the rules. So we have a woman who is a victim of domestic violence, a single mom now with three kids to support, I think it is. And the test at the board is, what's the degree? She had sponsored her parents when she was married, broke down. She doesn't have the money to sponsor, so she's before the board on a humanitarian appeal. The way they apply the humanitarian test at the board is that they look to the degree of inability to comply. So it is her very vulnerability that caused her to lose the appeal. She will never meet the financial guidelines. They know she won't meet them, although her parents and her brother would help support her and the kids if they came. So it's like a test that's turned on the woman, and she loses because that test is insensitive to her particular circumstances. That kind of thing is still there in areas of law. I mean, you know, I've been practicing that area for a long time, but I'd never sort of realized the impact until I had a single mom victim of domestic abuse, serious domestic abuse, who couldn't meet the financial guidelines.
Barb, I mean, that example resonates with our experience here at the clinic. I mean, there's a deeply gendered access to justice issue, particularly when you overlay that with poverty. That intersection is a deeply problematic one, and it's one that, you know, as your examples show, it's still something that's that is a real stain on our justice system. But over to you, Justice Martin.
Well, I would say, yes, there's still gender discrimination in institutions, in laws, in practices and procedures. Obviously, you know, and the intersection is with poverty, can be with race, can be with indigeneity. I mean, there's so many different ways in which people can feel pushed to the margins. And so it's really important that we understand how those things operate, so that the rules and everything around the delivery of service is it takes into account the very vulnerability that you're putting before the court. I mean, one or the decision maker. One of the most destabilizing observations is that equality seekers are making the case for equality in the very circumstances of inequality in which they live, right? And so once you understand that conundrum, it makes it a burden even to try to make the change, given that you know what the lived experience is. So yes.
I just wanted to say that if we looked at the proportion of unrepresented litigants, particularly I know in family law, we're going to find that the great majority of them are women. Often the men appear with representation, but the women are unrepresented. And if I just throw in one other case that we've just had recently, is a woman who was the breadwinner, but when they had an autistic child, she stayed at home with the autistic child. Now the child's ready to go to school. She's in a domestic violence situation. She has an autistic child. She doesn't have a plan of care that she needs from the schools to provide for the education. She needs retraining to return to the workforce, and she needs support, and she can't get it, and she doesn't have legal representation to require it from her spouse. So all of those levels.
Thank you all for your comments on that. I'm going to shift gears a little bit to get to some other questions from the audience. The next question concerns law school tuition. And we all know that law school tuition has been rising exponentially. And when we consider how law school tuition might constrain the choices of individuals who are coming to law school with respect to careers they might take on, the question is, should we be trying to mobilize the overall legal profession, the bench, the bar, and the legal academia in the direction of trying to get law school tuition back down to more reasonable levels? This particular audience member notes that when he went to law school, the tuition he paid was around $540 per year, which is probably no more than $5,000 when adjusted to 2022 dollars. So the question is, what should we be doing as various justice actors to deal with law school tuition, knowing the impact it has on ultimately these very issues that we're talking about?
Well, I just want to say that I have a good friend who is a refugee from Eritrea, who has done a degree in psychology and now in international relations, a graduate degree. He got a scholarship for that master's level, but he wants to go to law school. He wants to be an immigration and refugee lawyer, but there are no scholarships for poor refugee students. And that's why my number one request was offer scholarships to good students from poor backgrounds, from different diverse backgrounds. I think not only do we need to lower the tuition level, but we need scholarships to make sure that we have people that represent the diversity of our population and the kinds of challenges that they have. And we need to do more to recognize foreign credentials. I'll throw that one in as well, because people come here, we pick them because they've got their engineers and their doctors and their lawyers and they're wonderful people from another country, but we don't do anything to review their credentials while they're waiting in line to come to our country and figure out ways of making it easier for them to get up to speed and be contributing citizens. So that's just another inequity.
I think tuition, scholarship should be an interim measure. I mean, I really think that tuition shouldn't be that high. It should just be accessible. You shouldn't have to meet some standard where you get a scholarship, because I mean, who knows who's going to be a good lawyer? Some of the people I thought would be great lawyers, I don't know, weren't really great lawyers. And some of the people that I didn't think would be good lawyers have really, really done well. I mean, they've been, you can't sort of judge people. So scholarships require some form of judgment.
But there could be just a few.
Yeah, no, I said on an interim.
At the moment, like it's a total barrier. And this wonderful person is working as a helping people with their immigration problems. He's working as an assistant in an immigration office, but he wants to be a lawyer.
Yeah, I think on a transitional basis, there should be more scholarships, but really, I think the government should ensure, like I thought in Quebec, the tuition was affordable for most students. And if Quebec can do it, I don't know why Ontario can't too.
They've done it with daycare. They can do it with other things.
The Maytree Foundation used to have scholarships for refugees. So I don't know if they still offer it.
I'm going to write it down.
And Justice Martin, just from your vantage point with respect to this issue of law school tuition, especially given your experience in the legal academy.
Yeah, well, when professional faculty started to charge differential fees, this was a very big question, which was who will get access to law school. And the promise, I guess, was that there would be countervailing bursaries and scholarships to as the price of the augmenting of the professional faculties. I have not kept close tabs on how that has worked, but from what I read and what I read from young people, especially in Ontario, and the surveys that are done, is that has not actually happened. So kind of the quid pro quo for the augmentation hasn't been met on the access side. And the other way you can think about it is that to the extent that it's high and people are borrowing and their career choices are being constrained because they owe a lot of money and they, but for my student debt, I would be undertaking a different type of law. I think we have to look very seriously at that and find ways to have debt forgiveness programs for people who are doing the kind of work that needs to get done to make sure that there is access to justice. This would be a way of making sure that we are not just talking about it, but that we're giving real value to what we're saying by making sure that people are, again, allowed, rewarded, incentivized, and certainly not disincentivized to do this kind of work.
And it also pushes up their hourly rate when they graduate because they have to pay off their student debt. You know, which makes them again unaffordable to low-income people. So
Well, I wouldn't have been a lawyer, I don't think, if I was entering law school now.
I agree.
The tuition fee would have scared me off.
Well, I mean, when I went to law school, I could make enough money in the summer and working retail Thursday night, Friday nights, and all day Saturday to afford to go to law school, buy my books, and pay for my public transit so that I could leave law school without debt. And that is, you know, I did not come from a family with resources, but I'm not sure that is at all possible today. Though I've seen it with generations of students that I've taught. So
Yeah, it means we don't have a representative population. And we don't have people in many cases who've experienced the kinds of issues that we want people to be sensitive to. We don't, you know, I don't want people to have to suffer in order to go to law school, but I do think that we need a more representative sample. And yeah.
Yeah, I can't emphasize how significant of an issue this is. I mean, Barb and Dr. Landau, you spoke about your time in the clinic changing the trajectory of your careers.
Yeah.
We have students in the clinic here who are so moved and compelled by the work that they're doing that it is such a conflict to make the decision, and it is an anxiety and a stress that they take on to make the decision to move away from that area that they love and practice in a more lucrative area because of the debt that they've taken on. And it's really from my perspective as a director, it's a really tough situation because I completely understand it. You know, I don't know. It's as you all have been saying, I don't know how I could have had the experience that I had. Now, I simply do not, whether it be going to law school, being in the clinic, and then choosing refugee and immigration law as a career. So,
but can I just jump in on that and say, Joe Arvey, as many of you would know, was a lawyer in BC that did so much pro bono, so many constitutional cases, and very much was an advocate for the disenfranchised and he asked a question that I would just like to make sure that people who are here and listening and new lawyers, he said to them, ask yourself always the question as you proceed in your careers, am I doing noble work?
I think that's wonderful. Can I just throw in, Prasanna, a statement from one of the pro bono students that I just got today, from the students that I just had from their experience in the legal clinic? Could I just throw it in? Is that all right? Okay.
Of course, yeah, go
So I'm
ahead.
going to put, I had two law students working with the Durham Legal Clinic, but really working with separation pathways. They were assigned to us. This placement has been nothing short of amazing. As a student hoping to practice family law one day, this clinical placement has provided me with a foundational experience of what client-centered lawyering means. My favorite part was focusing on mediation and family law matters. Separation pathways placements give students a practical and fulfilling opportunity to learn the family law process. I will always remember this placement as a formative experience in my law career. That's pretty good.
That's excellent.
We have time to comment on, there's two questions that are in there that I sort of would like to make a comment about. Do we have time, Prasanna?
We are very quickly, we can. Yes, Barb.
I'll do
Go
it
ahead.
really, really quickly. One was respect for the client of legal aid and house humanity taught in the law school. And the other was, no, that was it. And the domestic violence one. I was just going to say, in terms of respect for the persons, I think dealing with your clients helps. I mean, one of the problems with lawyers is thinking that they know everything and they can sort of take over, and they don't bother to listen to the client. But I think that's one of the really important things going through the clinics, that you end up, because you don't know anything, so you're listening to your clients to tell you the story. And to build that into being a lawyer is really important, because I can't stand lawyers that rug rank. in the sense that they're more important than the client. And a lot of people do that.
One of the lessons that I've learned from this talk was captured in Justice Martin's kind of comment about advocacy grounded in the reality of people's lives. And unless you're prepared to sit and hear and truly understand the reality of people's lives, you are not going to be a good advocate. So just on that note, I wanted to express my sincere gratitude to this distinguished panel. Your comments were insightful and welcome, and we will be reflecting on them. I can tell you at the clinic, I can tell they sparked quite a bit of comments, or rather questions, and I'm sorry to the audience that we couldn't get to all of them.
Maybe you could share them with us. That would be great. If this is.
I can do that. I can
Thank
do
you.
that. So thank you so much and have a great afternoon all.